Counsel, if the coach, instead of taking a knee for prayer, took a knee during the national anthem because of moral opposition to racism, how would your school district respond? Would that be a Garcetti? Would that be government speech?
Well, Justice Thomas, if, for instance, the coach goes to the center of the field in front of everyone during the national anthem, absolutely that is government speech. But on Mr. Kennedy's theory, it's private speech, and more than that.
How is that government speech? Would you explain that to me?
Sure. In Garcetti, this court made clear that the test for government speech is a functional test, not a formalistic one, to determine whether the speech is pursuant to one's job. That has to entail looking at the manner, the time, and the place of the speech, and how reasonable observers would see it, whether they would view that as speech as a government employee. And so in the hypothetical that you just gave, that's the sort of thing, given that moment during the national anthem in the center of the field, and making this public act and public statement, that would be regulable. But
what if the school district, as it did here, objected to that conduct before it took place? How could that be government speech? Normally when I think of government speech, the government has a message and someone is communicating that message. How would it be government speech if, as it's happened in this case, the government objected beforehand?
A couple of responses, Your Honor. The first is that what the government speech test gets at is the recognition that school districts and other governmental entities have to be able to control their programs, and when they hire somebody to run that program, they have to make sure that it is their message that's being communicated. And under Mr. Kennedy's test, not only would so many things qualify as private just because the job description doesn't say, gee, if you go out to the center of the field during the national anthem, you are allowed or are not allowed to make political speeches. That becomes private, and it gets even worse for this reason. On Mr. Kennedy's theory, if the motivation for that act of protest against police misconduct is political, then it's subject to Pickering balancing. And yet, if it is the motivation is religious, it gets strict scrutiny. That makes no sense, and it is also inconsistent with this court's consistent holdings that political and religious speech have to be treated the same way. Political speech gets strict scrutiny in other contexts, but government employees are different. There has to be a balancing, and to have a different rule for religious speech would be impermissible viewpoint discrimination.
Counsel, here